Great. Well, hello everyone. I took a look at the slew of presentations and panels on the agenda today, and I was pleased to see a general theme of enthusiasm and a lot of puns. I think that's the right way to approach our industry. It's super interesting to us being people in cybersecurity and privacy and now AI, but you've seen how much effort it takes to convince people to care about something that we're so passionate about. So that's why I'm all about getting to know your neighbor. So I'm going to try to make this interactive. Feel free to chime off in the comments if you have questions. I will try to get to them at the end. So my name is Anokhy Desai, and I'm a cyber and privacy attorney. Let me know if this was a universal experience for you. You're sitting in your first grade class, and the teacher goes around the room asking everyone what they want to be when they grow up. You hear the classic answers, right? Firefighter, dancer, actor, teacher. I said I wanted to be a spy, but at 6 or 7 years old, the concept of being a spy is just about saving people from bad actors, and sometimes you have a very caffeinated tech person in some back room talking to you in an earpiece and giving you access to cool gadgets and hacking into the mainframe, right? So I grew up in the 90s, and we had a dedicated class period once a week to go to a computer lab on campus and learn how to use the internet and type and stay safe out there while using this new technology, and also just play a lot of games so we would get comfortable with using computers, unintentionally becoming tech support for our families. But that later evolved into cybersecurity when I got into college, because what is cyber if not saving people from bad actors and being your own tech person with access to those cool gadgets? Like now it's my turn to hack into the mainframe, right? Except probably not that. But what I didn't realize was I was actually subscribing to the concept of consumer protection. And to an extent, that's what we all do here. Even if you're the person responsible for making sure everyone in your organization goes through your training slides, right? You can check off your training and awareness box there. And everyone listens to your security training and doesn't leave their passwords on a sticky note open in their cubicle. You're protecting that consumer from having their account accessed without their consent, without authorization. And I didn't really plan to pivot, but in 2017, there were rumblings of this EU privacy law that was going to create a lot of work for businesses, but that also meant it was going to protect a lot of consumers. So I started a new role where it was just me and my manager trying to figure out what GDPR was in weekly calls with this London team. So every Monday I would go to my manager's office, I would sit there, she would close the door, I would be, completely silent. We'd sit in her office, and at the end of the call, we'd kind of stare at each other like, what's a controller? Like what is processing? What's a processing act? Are we joint controllers if we share activity, but we're not sharing a database? That was just very confusing, right? We're running around doing a lot of things manually for about a year. But then once the compliance date hit, I swear there was like an overnight switch that flipped in the professional world. You could see it on LinkedIn too. Folks were either relieved to be done, but were not planning on switching to privacy, or they were energized and made the switch and they were excited to start on this new thing. And that was me. So that was my formal pivot. And my manager and I were the only non-legal technical pair in the room of mostly lawyers, and a random set of other folks who were wondering why they weren't part of the team before. Like, why didn't we know each other before if so much of our work is overlapping? One person did vendor management, one person did SDLC work, someone else did physical records retention, so like a lot of just boxes and dealing with Iron Mountain and storage. And at that time, he was coincidentally starting to switch over to a digitized process and make it much less manual. So that worked out when we were trying to get rid of a lot of that paperwork. But I would talk to the legal team weekly in that role, and ended up asking the lawyer, who later became the head of privacy, what she would recommend if I wanted to stay in the field but not really let go of cyber. She said you can't forget cyber or your past work experiences or anything that you've learned. And those moments help inform your process throughout privacy. And that was nothing groundbreaking, but it was really good to hear, because I didn't feel like I was, leaving behind my friends in cyber, or that I was shutting a door on InfoSec when I started liking the privacy work. And she pointed me to law school and said, the way privacy is heading in the US, it's probably going to follow the Brussels effect. So for anyone who doesn't know, that's when the EU passes a law through their government center in Brussels, hence the name, and it has global impacts and ends up leading to other countries passing their own version of that law to cover their bases and make sure compliance is easier and expand their own consumer protection. And a large part of the issue in becoming GDPR compliant in the US was not having enough people who were able to understand the regulation, the legalese, and be able to translate that legal language for everyone and understand what was technically feasible for the companies that you're working in and get what the pain points were for other teams and. There's like just a long list. So it was just really helpful for everyone to slowly become cross-functional. So I pivoted again, and now I'm doing the same thing that I wanted to do before and that I was doing before, but I can appear in court. But in this whole thing, I know I'm not unique, right? Cyber and privacy professionals have really had to learn parts of each other's jobs the last few years. And we know that was triggered by the GDPR, that was triggered by the CCPA in 2018, and again when it was updated in 2020 by the CPRA, and again every time a new state law passes. And we're on 16 states so far, and it's looking like it's going to head to 50. So I'm sure a lot of you have both cyber and privacy listed in your job description. And if you didn't before, you might in the future. Or you don't have it listed, but you understand that it's an unofficial job duty to be able to understand cybersecurity or privacy concepts or both, whichever side of the aisle that you're on. So starting with the layoffs during the pandemic, we've seen roles get consolidated. We've seen separate departmental budgets become shared budgets for both teams. And we've seen both sides' priorities become deprioritized unless there was a guaranteed fine attached. We've had to kind of negotiate over who gets the budget for this very important thing if you don't have a regulation coming up that requires you to have that budget. And unless you work for the government where NIST compliance is required and you know that you won't have to fight over the budget with your privacy or cyber counterparts, it can get frustrating. We're not profit centers, we're cost centers, and we get told that all the time. So how do we even do our jobs? Following best practices is always advisable, right? It's like the number one thing that comes out of your mouth if you are advising to your own company or if you're consulting. But it becomes optional if your company's stakeholders think the organization is too small to become subject to an investigation, or they've already done the annual audit last year and nothing much has changed this year, so it wouldn't hurt to skip this year. Or hiring outside consultants to perform security tests is expensive. And I mean, look at the round of layoffs we've had to do the last few years because we've had to cut costs. And organizations can also feel immunized if they've already been in the center of a separate incident, as if getting breached in January can't possibly lead to a separate enforcement from the Federal Trade Commission or the Attorney General's office or even like a HIPAA violation, because lightning never strikes twice in the same spot. But you know how we can get stakeholder buy-in and support so we can actually do our jobs? We bring receipts. We give them receipts. They already know about Equifax. That's old news. It's not going to change any minds. If anyone is new to security, welcome to our world, and please help us grow our forces. Equifax is a credit reporting agency that had to pay $600 million because in 2017, it failed to apply a critical software fix and implement security measures like encryption, and that led to a breach that exposed the personal information of 147 million consumers. And aside from the fine, they were and still are under scrutiny to implement and maintain security safeguards and upgrades from their original processes. I'm going to cover 3 cases where organizations faced enforcement actions for privacy harms that were actually based in cybersecurity violations. So you have receipts to give to your stakeholders. So Anthem, also known as Anthem Blue Cross Blue Shield, is a health insurance provider with the second largest insurance market share in the US. So if you don't have them as your insurance card provider, you might in the future. In 2014, they faced a data breach that affected the personal information of almost 79 million consumers. That included names, home addresses, email addresses, social security numbers, healthcare ID numbers, and dates of birth. So like almost every type of PII. They didn't announce the breach until 2015, a few months later, and then they shared their investigation. What happened was attackers sent employees of an Anthem subsidiary spear phishing emails containing malware, and one employee responded. And we know that's all it takes, right? So that opened the door to let them hang out in Anthem's network for months to access and download data from the most sensitive databases. And it turned out Anthem had a lot of, quote, deficiencies in basic security in their investigation report, like not limiting access to computers holding sensitive information. That's a big one. Not protecting account credentials and passwords from unauthorized use with additional layers of security, not updating their security tools, and not adequately logging and monitoring network activity. So cyber folks, this is all run of the mill, right? It sounds like they need better access controls, defense in depth, identification and authentication mechanisms, and maybe an updated SIEM tool. But the California Attorney General's office initiated legal action against the company for violating consumer protection and privacy laws in 2020 and received $8.69 million in a 2020 settlement against Anthem. The AG at the time said, when consumers must disclose confidential personal information to health insurers, these companies owe their consumers the duty to protect their private data. Consumers are left with little choice but to trust that their personal health information will be safe and secure. So in 2015, they got hit again. HIPAA requires organizations who face a data breach or security incident that compromises the electronic private health information of at least 500 individuals to report it to OCR. That's the Office of Civil Rights within the Health and Human Services Department. So because Anthem had a legal duty to report their breach there, they reported it to OCR and ended up paying $16 million prior to that 2020 enforcement action with the California Attorney General's office, and they had to commit to updating their security practices. So it was a big fine at the time, and they had no reason to think that they'd be in another spotlight after being on the HIPAA shame board for just years prior. And for context, if you haven't seen the shame board, it's basically OCR's running list of companies that violated HIPAA. They have separate lists for companies under active investigation and resolved cases that date back to the beginning of the HITECH Act requirement to start up the shame board. If you just Google HIPAA shame board, it'll be the first link there. The OCR director at the time said, the largest health data breach in the US history fully merits the largest HIPAA settlement in history. This is a good case to bring up to stakeholders who don't fully grasp that you can get hit twice or more from the same incident. There's no such thing as paying your dues and being done. Anthem's 2014 breach led to a HIPAA fine with security commitments and a California fine for consumer protection and privacy law violations that was fully resolved 6 years later because legal proceedings take a long time, so you can still be on the hook well after the incident is over. All right, case number 2. I hadn't heard of this company before the enforcement action, so it kind of gave me hope for the sense of justice. Like, oh, good, unknown companies are having to protect user data too. It's not always Meta and Google in the news. But I looked into the company, and while the news came out, I realized why no one had really heard of it outside of certain industries. Global Tel Link is a prison communications provider. So they basically provide a calling system that inmates can use to call their family and friends and lawyers. And depending on the type of call, the recipient of the call pays, or the charge comes out of the inmate's funds. You can see how this becomes a problem, especially when you learn that Global Tel Link had a 50% market share of this very niche industry 10 years ago, and has slowly gained more over the years. Global Tel Link and another company currently share 90% of the market right now. So the company has actually faced a lot of controversy before their security incident by coming under fire by the FCC, the Federal Communications Commission, for increasing the price of phone calls. The FCC was stalled for a few years, but was able to reduce the cost in 2021. They're also owned by Veritas Capital and other private equity firms that have been in the news as well. and they came under fire in 2017 and ended up paying $2.5 million in a bribery lawsuit. And the Mississippi Attorney General went after them for racketeering charges, which sounds super old school, but that's also a list of bribery and money laundering schemes and crimes. So this kind of gives you some insight into where their priorities lied, not in security. In 2023, the FTC filed a complaint against the company and two of its subsidiaries that said they failed to secure the sensitive data of hundreds of thousands of users stored in the cloud and failed to alert everyone affected. That's already a red flag, but now that we know who that affected, you can see how that was problematic. You're in prison. You don't have access to your digital footprint, but you're also subject to a breach and you weren't notified. So what happened was the company claimed it had good security practices and said data security was, quote, the cornerstone of what they did in their marketing materials and online on their website. And it implemented a security architecture and it was state of the art and they had safeguards like encryption in place. But in 2020, they copied over about 650,000 user files and PII into a testing environment in the cloud in plain text without a firewall and didn't implement monitoring software that would have otherwise alerted the company if security settings were changed. This includes full names, date of birth, phone numbers, usernames or email addresses, plus the passwords, social security numbers, the worst, location information, and messages between those users and their family and friends. So that left information available up on the internet for free, unprotected, until a security researcher found the stash and alerted the company, and they did nothing. A forensics company found that several hackers accessed the exposed data and the company did nothing. Then an identity monitoring company notified them that the plain text data was not just available on the web, but it was also found on the dark web, available for purchase, and they did nothing. They waited 9 months to notify customers and only contacted 45,000 of the 650,000 affected individuals, which left enough people in the lurch about whether their identity was stolen, what to do about it, whether to contact someone on the outside to freeze their credit. And on top of that, the company also repeatedly and falsely claimed in their marketing materials after all of this happened that they never suffered a data breach because it can't be a breach of data if it's available online with no protections for someone to access it without authority. Anyway, so the FTC finalized their decision on a consent decree with a unanimous vote, and there's a 25-page order of what global Tel Link needs to do with their security. They need to up it overall. They'll essentially be under a microscope for years, and will have to do things like implement a comprehensive data security program, notify users affected by the breach who weren't previously notified, and give them free credit monitoring and identity protection services. Going forward, they have to notify consumers and facilities within 30 days of detecting a breach or security incident that triggers any federal, state, or local breach reporting requirements. And specifically, they have to notify the FTC within 10 days of that previous notification of reporting any security incident to any other authority. So the FTC primarily enforces privacy issues rather than security issues, but it uses security failings to trigger the applicable statutes. The director of the FTC's Bureau of Consumer Protection had the usual spiel of the importance of protecting the right to privacy of personal information for all consumers, and then said, when consumers have little to no choice about whether to use a business's products or services, the business has an even greater responsibility to ensure that its practices don't cause harm. We're seeing a theme here, right? Now, this is a good case to bring to any decision maker or stakeholder who need to be convinced that security and privacy are important and different, but interrelated practices that both need attention. You can't brush an incident under the rug as being unimportant, and especially if a random hacker or security researcher brings this issue up to you, it might already be too late. The unencrypted and unprotected data was only up there for 3 days, but it still caused so much damage. All right, we're on our last example, doing good on time. If you haven't gotten ads for GoodRx all over Instagram and YouTube, just know that it's a company that provides information on discount prescription drugs, and has a telehealth platform that served over 55 million customers since 2017. So since 2017, GoodRx promised its users that it wouldn't share personal health information with advertisers or other third parties, but it ended up violating this by sharing sensitive personal health information like users' prescription medications and health conditions with advertising companies and the usual platforms, right? Facebook, Google, Criteo, through user identifiers that were used for advertising. There's a specific instance listed in the FTC complaint that in 2019, GoodRx compiled lists of its users who had purchased specific drugs for things like heart disease and blood pressure and uploaded their email addresses, phone numbers, and mobile advertising IDs to Facebook so it could identify their profiles for more targeted advertising. There were also some self-regulatory issues like the fact that they displayed a HIPAA compliance seal at the bottom of their telehealth services page when it wasn't HIPAA compliant because of their personal health sharing data practices. And they claimed that they were compliant with the Digital Advertising Alliance principles when they really weren't, because they weren't getting user consent before using health information for advertising. That last part is pretty common for DAA violations, but it's a self-regulatory group, so it's up to member companies to have their proof ready to show that they are asking for unambiguous consent before doing that kind of sensitive advertising. So when a consumer watchdog revealed a bunch of GoodRx's practices in 2020, they didn't have a sufficient formal, written, or standard privacy or data sharing policy or compliance program related to this in place, and they had to scramble to solve that after all the public attention. Because of this whole list of violations, the Department of Justice filed an order on behalf of the FTC to prohibit GoodRx from sharing user health data with third parties for advertising and fined the company a $1.5 million civil penalty. So this last takeaway is a bit tricky because it's not outright a security flaw or a breach that then led to a privacy issue and a giant fine, but a regulatory issue that both security and privacy people can learn from. When there's a regulatory issue that touches privacy or security, the best thing to do is team up with your counterpart because they likely know something you don't, they've heard of something that you might not have, and getting to the bottom of an issue before it blows up, before it leads to a giant monetary penalty and causes a bunch of customers to stop using your service because of the bad PR, that makes both of you the hero. And we need each other. And legal teams at companies that have been subject to these types of enforcement actions can attest to that security and privacy are both important to mitigate, if not prevent, disaster. If you look at privacy laws popping out of the woodwork, you'll see one thing they all share is the business requirement to have risk assessments regularly. Looking at the text of all these laws, which I've done, clarifies that this is a broad requirement that means cyber risk assessments, controls assessments, data privacy impact assessments, or some combination. And for reference, this is just a section of the Comprehensive Privacy Law State Tracker kept up to date by the IAPP. And there are 16 states that have passed comprehensive privacy laws and many more that have proposed them. And all of the laws that have passed and are currently in force or will soon be enforced all require that risk assessment requirement. You'll see just X's down the line. The fact that we have different teams and titles for our roles means that our organizations know the importance of having us around. When I say convincing your stakeholders and getting buy-in, I'm talking about those moments when you have to present on a new vulnerability or explain why some company's in the news and whether your organization has anything to do about it. Businesses typically don't like spending money, and I know this sounds obvious, we all know this, but when you and a few others may be the only folks in your department who understand the impact that a certain enforcement action will have on your policies, or whether you'll have to overhaul your entire internal processes, you need to be able to bring these receipts. Security and privacy isn't just about complying with controls and standards and laws, but about making sure information is protected, whether it's internal to the company or consumer data. And that's where working with your privacy or security buddy comes into play. You may realize you have the same goal in mind, just with different paths to get there, and suddenly your team of two is a team of three. Especially with AI professionals joining forces with us to make sure company technology is being used reasonably and responsibly, we might find ourselves expanding our tent to include even more neighbors. So I hope you enjoyed all the corny references and the GIFs, but security and privacy folks really are just two different types of the same actor within the company. Our job is to protect data, and whether that's internal to the company or client data. We're just here to make sure that everything is secure and no one has access to things that they shouldn't have access to. All right, well, thank you, thank you. If anyone has questions, you can put it in the chat, or I know we're running short on time, so you can feel free to reach out to me on LinkedIn. I do read all of my my DMs, so feel free to send a note with that invite so that I know that it's a question about this.